Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. I'm also here to talk to you about a major update that's happening, and we need to talk about it because there may be some strategy that has to go into this to make sure that you can have continued protection from deportation. So, one of the major changes that they're making in the policy manual is that they have made very clear that if you are filing a family petition, this is an I-130 petition, and they find in the process of you filing the I-130 that you are removable, meaning they do determine that you should be referred for deportation. They're saying while you have a pending petition, that they can actually refer you to removal proceedings. Now, here's where strategy is very important because what they're referring to here in the policy manual is the petition. Remember, when you're filing for the green card, there are very important documents that you have to file. You have to file the petition, we're talking about family and marriage-based cases now. That petition is the I-130. And then in addition to that, you file an adjustment of status application. That adjustment of status application allows you, if you're here in the US, to be able to stay in the US, get your work permit, and wait for them to give you your approval. The thing about it is they're saying that if you file a petition and you don't have that adjustment of status process going that you qualify for, they could then refer you to removal. Now, they haven't said this explicitly, but based on my own experience, that's what they're saying here is the I-130 petition, filing an I-130 petition by itself does not give you protection. It does not protect you from deportation. So if they see fit to send your case to removal, even while your case is pending, it doesn't even have to be denied. They can do that. But here's what reduces the possibility of that happening. If you qualify for adjustment of status, you need to make sure that that is filed along with your I-130 petition, because it is the adjustment of status application while it is pending that allows you to get temporary permission to be here while your case is pending. And it can even help you to stop you from being deported. I'll give you an example. If you were here and you overstayed your visa, right, and you have a US citizen spouse, because they are saying this can happen with marriage-based cases. You have a US citizen spouse, but you didn't know that you should be filing this adjustment of status application along with the petition. And this comes with inexperience, of course, and trying to do it yourself or doing it through a non-attorney. But say you get the advice or you don't have the experience to know you have to file the adjustment of status at the same time, you file a marriage-based petition, the I-130, and then you're like, okay, you're going to wait until it gets approved, then you'll file the adjustment of status. The thing about that is they can then say, oh, okay, yeah, the I-130 looks like it's approvable, but we don't see an adjustment of status application, and based on the overstay, they are removable. So we can refer them for removal, and they can sort. If they do get deported, they can always sort out the I-130 process outside of the U.S. Right. So that's what they're saying here is that if they identify that you should be removed and referred to immigration court, um, and you don't have anything that's stopping that from happening because you only have a petition pending, they can still move forward with removal. So the point here, guys, is very, very important to ensure that you, one, are following the correct case strategy, that you're not missing steps, and that you do qualify for an adjustment of status application, because the adjustment of status application can get you temporary protection until you can get the permanent protection through approval. So that's happening, right? What they're saying now is they're going to be very, very quick to issue notices to appear where they see the opportunity to do that. So there's a very, very little room for errors here. Very little room for errors. Here's another cautionary situation that could trigger a notice to appear to deportation. If you are, and this happens a lot, where you have a parent, you're over the age of 21 years old, and you have a US citizen parent here, and you are under the impression that you could be here, maybe even overstay your visa, and then your US citizen parent could just file for you, and that will fix everything. So your parent files the I-130 petition. The thing is, you don't qualify for adjustment of status yet, and you probably will not be able to qualify for adjustment of status after an overstay. But most people have, many people make the very bad mistake of thinking, my parent could file the I-130 petition and fix it. Well, under this administration, what's going to happen is they get that I-130, they realize that you've overstayed your visa, they see that you don't qualify for adjustment of status, and they don't have to deny the I-130, it might even be approved. But what they are going to do is issue a notice to appear so you can go to immigration court for removal, because now they see, oh, you overstayed, you don't qualify for adjustment of status, you need to deal with the I-130 from outside of the country. So unfortunately, uh, filing a petition and being here in the US and having an overstay does present a risk now. So you have to tread very carefully. You have to strategize. You have to understand the implications or what to expect if you are thinking about filing an I-130, unfortunately. Now, keep in mind, by the way, that being referred, getting a notice to appear does not mean that you're going to just be put on a plane and sent right out of the country. You're just going to go before a judge. And of course, there is the added risk of detention. So that there is that. But I want you to know that a notice to appear does not mean you're just going to be sent out of the country. It means that you still have the opportunity to defend yourself and to apply for your immigration benefits before an immigration judge. So it's not the end of things, but it does complicate things. And that's why it's very important now to sit down and really consider whether filing an I-130 petition is going to be a good idea, or what the game plan is going to be, and whether you do qualify for adjustment of status, because having a pending adjustment of status is what is going to be able to let them put a hold on removal while that decision is going forward. So I really hope that this clears that up for you or clarifies it for you. It does make the process more stressful, riskier, especially when it comes with more risk, especially if you want to file for an I-130 petition, but you don't qualify for adjustment of status, right? Another thing that's happening here with a major change is that they they are not giving chances, right? So if you submit a petition And because a lot of people will rush to file a petition because they think that the petition is just going to protect them and that they just need to get it in. Sometimes you do have to meet a deadline, absolutely. But now you have to make sure you're stopping to put a solid application together. The reason being, they have now made it very clear that they have the right to say denied, flat out. If you don't submit a proper application, if something is missing from your application, your petition, if something, a required document is missing, they can turn around and say just denied. And when they without a request for evidence. And the danger with that, though, guys, is now with a denial, they're quickly now turning around and sending a notice to appear right after. And the thing about that is once you get a notice to appear, it is before the judge, and the wheels turn very slowly. It is a stressful process because, of course, you do face the added risk of being detained, possibly you do, and it is the last chance to prove that you qualify for a benefit to stay in the United States. So, it don't take this lightly. I hear a lot of people saying things like, I'll just go get married and get the green card then. Well, this administration is not making any process easy. Even marrying a US citizen is not going to be easy, and a wrong move can get you placed in removal proceedings instead. So do not take it for granted. Give us a call. Let's talk. At the firm, we have attorneys here. I work very closely with these attorneys that help us to determine who qualifies, what's the best way to apply for immigration benefits, and to move forward there. Now, I do want to make very clear that yes, these policies make it a lot harder. However, we have been seeing victories here in the office, inspirational victories that keep us moving forward. We have gotten asylum approval, T visa approvals, green card approvals. Our approvals are moving forward as they have been. And I do anticipate we are going to have to work a lot harder. We're going to have to push a lot harder, and we're ready for that, to make sure that our clients' cases do succeed. But it is still possible because we are applying based on the written law, but there's going to be a lot more strategy involved, a lot more thinking about whether it is a good idea to file the I-130 and what kind of risks are presented to you. So I want you to keep that in mind. The final thing that I want to talk about here and talk to you about the implications of that is they have made very clear in the policy manual that the withdraw, so a sponsor, if a parent, if a spouse, if an adult child, if they are telling you they are thinking about withdrawing your petition. It happens often, especially when they want to hold the immigration process over your head. And they start to say they're going to withdraw your application. And anytime you get into a fight, you need to take that very seriously, because the next thing that they've made very clear is that if the person if the petitioner, your US citizen or your permanent resident spouse, parent, or adult citizen child writes the USCIS to withdraw the application, there's no turning back. It is final once they withdraw it. And they can even withdraw the application, the petition, after approval. of the petition, which means ultimately that they can revoke your ability to get the green card. Because when the green card is dependent on the I-130 being approved, and if that is withdrawn, everything else collapses. Right. And they said that if say you got your approval on July 14th, and say your spouse, your parent, your adult child wrote a letter to the USCIS to have it withdrawn. That point, you only have an approval. They have not issued your green card yet. At that point, with an approved petition, no green card issued, they can turn around and say, okay, it's withdrawn. And then they can withdraw. With the withdrawal comes taking away that approval as well. So by August 1st, you could get notification this decision has been revoked, and because the petition has been withdrawn. Now, in a case like this, I would say this, and I'm giving you a strategic approach to this situation now, because I know some of you that are listening, you're going through something like this where you're fretting because maybe your spouse, your parent, or even your adult child is threatening to withdraw your petition. If they're mistreating you, if they're doing things like this, holding it over your head, that's abuse. And that means that you can take this process into your own control by applying for VAWA. So instead of pursuing the I-130 petition and fretting about whether they are going to withdraw your application and take away your ability to get the green card, you can switch to the VAWA process that would allow you to have control. It would allow you to be able to pursue your green card by yourself through a confidential process. And I would say in that case, it's urgent because you don't want it to get to the point where they withdraw it. It just makes the process more tedious, and you could get a notice to appear, right, in immigration court. Because the minute they take away that petition or they deny your case, they're going to a notice to appear, they're going to swoop in with a notice to appear and then complicate your case. Because when it gets to immigration court, we have to go through the court to try to get your case dismissed or terminated in order to get you back on track to get the green card. So it's urgent at this point. We have done this for our clients in the past where they have their green card was at risk because the sponsor was either withdrew it or they were sabotaging the green card process. So we switched over to the VAWA process and explained what was happening, the kind of mistreatment and abuse that was happening. And our clients now, some of our clients do have protection and they do have their 10-year green card because of that. And we've gotten those just this year without an interview. The process does take a while. The VAWA process, if you're switching, it does take a while, but keep in mind, you will be able to get your work permit or maintain your work permit while you wait for the process to be completed. That gives you the ability to get temporary protection until the decision is made. All right, so those are some of the noteworthy changes that are coming. Of course, interviews is another one. I did talk about that yesterday. I won't get too much into it because I do want to get to your questions. But keep in mind that because these policy changes have been put in place, making any mistakes could trigger a fraud investigation or straight up denial, and that could then cause you to be referred to immigration court very shortly after. So make sure, it doesn't mean all hope is lost, but it does mean that the case is going to get a lot more complicated and a lot more expensive. So make sure that you are you are strategizing, you're approaching this with care, not don't rush. We yes get working as with working to make sure everything is done as soon as possible is essential. That's what we do here at the firm. But we do not replace quality with speed, because that is where things can get messy. All right, so I'm going to answer some questions. I see some questions. I'm going to start with TikTok, and then I'm going to go to YouTube, Facebook. Hello, Lorna. Nice to see you. So put those questions in the comments. I see some coming in. And then on Instagram. So hang tight. And, I know we can all learn from the kinds of questions that we're going to be getting here. So file T in March. How many months for EAD or approval? So I would say 6 months after receipt of your receipt notice, about 6 to 8 months. Can I get admin closure for termination? I have asylum pending and I have SIJS, but no deferred action. It's possible there may you may negotiate to see if you can get a joint motion. I mean, those are those are going to be a lot rarer because of the stance of this administration. But it does not mean that an immigration judge can't also make that decision through a motion. F1 with misdemeanor charge. Should I travel outside the states? I'm worried about denied entry. Yeah, you should be worried. So a misdemeanor charge with a visa it can definitely cause your student visa to be canceled or revoked and for your entry to be denied. So I would be very cautious. The first step you have to take before you do any traveling is get legal advice about what does this misdemeanor mean for your visa? Does it render you deportable? Does it render you inadmissible? And then go from there. How long is VAWA taking? I'd say 3 to 3.5 years. Now, the USCIS does have their range of time, so you can check out the range of time it takes, but on average, I'm seeing about 3 to 3.5 years. Nadia, I see. Thank you so much. Okay, you're welcome. My husband refused to sign my paperwork for my conditional green card. What can I do? You have options. If your spouse refuse to help you to go from the 2 year to the 10 year, you can apply for waivers. If a spouse is refusing to help you to get to the next step to maintain your stability here in the US, that's a problem. That's a major red flag. And that could indicate even abuse or mistreatment or extreme cruelty. Get in touch with us. We've gotten approvals based on situations like this, but we need to talk to you. It's urgent. Get on it so you don't miss the deadline, because you miss the deadline to apply for your 10 year green card, you could be referred to immigration court, and it gets a lot more complicated from there. So we can file an I-751 with a waiver that allows you to apply without involving your spouse. That may be the best option for you here. Can green card holders travel to Canada and return to the US without restrictions? Yes, my clients just did it. Our clients went to Canada and no complaints there, no complications. Now, keep in mind though, it really not every case is different. Not because my clients did it means you can do it. What's in your background? Is there anything of concern that could cause them to deny you entry or turn around and try to revoke your green card? I mean, as a green card holder, they will likely will not deny you entry, but they will refer you to immigration court in order to try to revoke your green card. And we have seen In rare occasions, we've seen detentions of green card holders who have had past criminal records. So we want to know what's going on in your background. You would want to talk to an attorney to figure that out, whether it can affect you. I have court in December. I'm a DACA and I'm in removal proceedings. What can I do? So you're in removal proceedings. As I said before, being in removal proceeding does not mean that you can't succeed. There are ways and options. You have cancellation of removal. You do have the ability to get withholding of removal if you don't qualify for asylum or CAT, just depending on the conditions in your country. There are options like VAWA, if you're being mistreated by certain relatives. So, but it depends on any relief or defenses you're going to have. It's going to depend on your particular facts. So this is where it's very important to get in touch with us. Married to a US citizen, but now living in Greece for 3 years. Can I apply for a marital visa? Yes, yes, you could. Your US citizen spouse would be able to file for you, and then you'd be able to come to the US on a special visa and become a green card holder. What do you know about the I-130? The I-130 is a petition that's used to show a qualifying relationship between a U.S. citizen, a qualifying U.S. citizen, and an immigrant for them to get the green card. So that's what the petition is for. But keep in mind, usually that petition is processed, the final interview is outside of the United States. But if you're in the United States, then an I-485 would have to be filed to allow you to stay here and get your green card. I'm doing VAWA and I'm approved for my I-797. I'm waiting on approval for I-485. Yes, that's the next step. I-485 means green card, that you get your green card while being here. That I'm seeing that taking 6 to 12 months after approval of the VAWA. Is it okay if you came here legally and tried to do your adjustment of status? If you qualify for the adjustment of status, that's fine. And keep in mind, adjustment of status in some cases does not even require you to show that you entered the country legally. In most cases, it's required. But for example, VAWA, asylum, the T visa, the U visa, not necessarily. Have you heard any updates on people who registered? You see alien registration requirement. So no, we I haven't seen anything where anybody has been detained based on that registration. Do taxes have to be paid before applying citizenship? Are payment plans acceptable? Payment plans are acceptable. It shows that you are resolving your tax issues, you're complying with it. That's fine. What will happen if you get the notice and don't go? So if you get the notice and you don't go, that can be one of the worst things because it means then that the judge is going to issue a deportation order in your absence. And that means that if they find you, they just take you and deport you because you have a deportation order already. You never showed up. So it's very important to go to your hearings and comply with it because that's your best bet to put up a good defense. What is the lip color? I'm not sure what the lip color is. I don't know. I know it's Sephora, but I don't know what this lip color is. What will happen if you get the notice and you don't go? So answer that. We're waiting for the pardon where they make you leave the United States to the city of Juarez. So yeah, the I-601A waiver. So yeah, that's fine. because you'd be going through consular processing then. Do taxes have to be paid before applying citizenship? You just have to show that you're complying. So that payment plan is fine. Yeah. Is it safe to travel for 3 weeks in Europe with travel authorization form, VAWA? No, that's a really, really tricky question. I am, as usual, with all the answers I'm giving here, keep in mind it's general information, it's not personalized legal advice. You need to make sure you call us and schedule an appointment with either us or an attorney to talk. Oh, I Frankly, I am not advising people to travel on their travel document. Leaving for 3 weeks on a travel document right now in this day and age can be risky. It's not travel, having a travel document is not the same as having a green card, right? If they still have the ability to deny you entry, the travel document just makes it a little better for you. But if they find anything that they determine is makes you inadmissible, they can always deny you entry or then send you to removal proceedings. So, um, what makes one not qualified for adjustment of status? So, keep in mind that there are options to adjust status even if you enter the country without permission and even if you overstayed your visa. However, those would be in the case of VAWA, for example, or the T visa or asylum. If you don't fall into any of those situations and you ended up entering the country without permission, adjustment of status is not going to be for you unless you're applying for VAWA. So, so keep that in mind. Um, that there are options. It's very important to make sure that you look at those options. Now, I see somebody answering questions in the chat. Please do not walk away with advice from people who are answering questions in the chat. Because especially now, guys, we cannot be listening to village lawyers. I call non-lawyers who want to give advice village lawyers because that's where the risks are coming. That's where the errors are coming. That's where people think they don't have options or they're misinformed. So please make sure you're not taking any advice from people in the chat. Make sure you are consulting an attorney. Make sure you're calling us, you're talking to us. We have our attorneys talk directly to everybody that books an appointment. Now is not the time to take advice from just anybody. And that's the point of the information I'm giving you here is there's a lot at stake. So you need to now be very strategic and very careful about the information you're absorbing and where you're getting it from. All right. How long for approval? 2023. So you could be looking at about 3 years. Keep in mind that you could qualify for the work permit and adjustment of status. That does give you some protection. Um, I entered the USA legally. I'm currently asylee, have approved asylum. Is there any risk for me? Uh, So you're in the best case scenario that you could be in, right? You're approved for a benefit, you've gotten protection. So you're in the best case scenario. If something changes that does not qualify you, that's where something could go wrong. But why, at this point, it sounds like everything is good. So savor that and just keep moving forward with positivity. Um, now, applying for the green card, you have to just make sure that you're consistent, that you provide a lot of more detail in your application because they are doing a lot of fraud detection screening when it gets to the green card stage again. Submitted minor son's petition 2 years ago, update stage reviewing, and nothing outstanding. Next step, so you might get a decision. But don't hold your breath. It could be tomorrow, it could be a year from now. Should I file my I-45 ASAP? I have an I-130 pending 8 months from USC adult child. Legal entry overstay. So this is exactly the kind of situation where you want to make sure you have, and if you're here in the US, which you said, you have the overstay, that you want to make sure you have an I-45. I don't know if you have a lawyer. If you are having doubts, make sure you're getting legal advice and representation. But in a case like this, an I-45 is totally appropriate, and that is what can give you certain protections. So that I-130 that's pending is not giving you protection. So if you only have an I-130 pending, and then they see that overstay, they could possibly say they're sending you to immigration court because you haven't applied for adjustment of status. So applying for adjustment of status is essential. Now, here's the deal too. When you're applying for adjustment of status, you need to make sure that you submit certain required documents like the affidavit of support and your sealed medical. They will not process the adjustment of status without those. So this is why it's very important to make sure you have representation because the stakes just got a lot higher. And really and truly, in many cases, people are just going to have one shot at it. Um, can an illegal immigrant adjust his status by getting married to a U.S. citizen who is on asylum? So a U.S. citizen would not be on asylum. A U.S. citizen is a U.S. citizen. If if they were an asylee, then eventually got U.S. citizenship. I think that's what you're saying. No. Now, if you are in a situation where your spouse is mistreating you, that VAWA does allow you to adjust status without, even if you enter the country without permission. But if the spouse is petitioning for you, it will not allow you to adjust status with an illegal entry. Can I file in 600K for a 17-year-old who live abroad? Does he need to be in the US first? So usually with that case, no, these are very specific cases. This is where the child is deriving citizenship from a US citizen, one or two US citizen parents, but we'd have to understand what the circumstances are to determine which one is going to be the most appropriate. How long does step sibling filing for over 21 step sibling take? Does it help in a deportation? It takes 14 years at minimum. So it's not going to be the best solution, and it does not offer a strong defense to deportation because it takes so long. They're just going to say, okay, we'll deport you, and you can figure that petition out from outside of the United States. What if they ask my friend for more evidence for her FAWA I-45, but she got divorced and don't have much? Well, in this case, it really comes down to strategizing, planning, figuring out what you do have. If you're usually there is something. but we have that, this is where having representation is essential, because in a case like that, me and my team, we sit down in a meeting and we talk about the case, and then we meet with our client and we go over everything with our client, and we all brainstorm together. What do you remember? What do you have? So, in a case like this, that really, I would not be able to come up with solutions unless, we're the attorney on the case. Have pending I-45 prevent from deportation. Having a pending I-45 will prevent deportation. It offers temporary protection while your case is going forward. Yes. And so that's where it is different than an pending petition. The pending petition does not offer protection. An pending I-45 that you do qualify for does provide that level of protection, temporary protection. Can I file for a CRBA with 2.5 years of physical presence in the US? I was born in New York. So I would want to talk to you. If you're born in New York, what's the problem? So I would need to figure that part out. So if you really want to move forward with, proof of citizenship, get in touch with us. Because if you're born in New York, why can't you just use your birth certificate? I and my file, our taxes separately. Can it affect my citizenship status? It there may be an issue if it indicates some kind of inconsistencies in your application. Sometimes they may ask, well, if you're married, living together, why are you filing taxes separately? So it just depends on the facts. My wife is a green card holder. Can I have, or will I get a permit if I have, so if your wife is a green card holder, that this is another situation that can be tricky, because you file the I-130 and you're here in the US, you end up overstaying. That can open the door for you to get a notice to appear, because you don't qualify for adjustment of status, and now they've spotted an overstay, and so they can issue a notice to appear, and that could complicate your case. No, so I'm not saying can't be done, but definitely you need legal advice about how to approach this. If bond was denied, we appealed it and the government didn't respond to briefing, is that good? Possibly. If they, you know, if you provided your briefing, they didn't, then it means that they did not provide their legal arguments, which could go in your favor. So it just depends. Um, if they're doing another hearing though, and they show up for the hearing, that may change things too. How soon can a green card holder file for his wife? Right away. But as I said before, really and truly, the strategy now is going to be dependent on what's on your specific facts. My mom been in Mexico 15 years already, and her I-130 got approved today. Do you think they will make, so if it's approved, the next step is the green card process, where they're gonna send it to the embassy. Usually you're looking at about another year and a half to 2 years of processing. Um, Visa overstay was on F1. We got an interview AOS through marriage. Any advice? Um, Yeah, so prepare for that interview very carefully, very thoroughly. Please don't take it for granted. Know your application. Make sure you look at a copy of the application you submitted, know line by line what you have in that application. If there's anything missing, make sure you have that information ready to provide to the officer. Bring your original documents, passports, birth certificates, marriage certificates, if you have children, birth certificates of the children. Make sure you bring your photos if this is marriage based, photos with, for example, you can create a little album and then put your best pictures in the album. I usually say it's important to put different dates, times, seasons, holidays, people make sure you're mixing it up. Don't just give them, the 10 wedding photos that you have. They don't want to see I mean, wedding photos, nice, but they want to see your life together. And actually just presenting wedding photos can be a red flag to them. So do you think they will waive her interview since she's in Mexico and I'm a US citizen? No. They're gonna call her for an interview at the embassy. They What they do evaluate at the embassy is admissibility. So she's gonna do her medical and then they're gonna call her for an interview. So you have quite a ways to go. File tax in late 2020, but I don't owe money with mail certificate. Is that a problem for citizenship? If you file your taxes, you don't owe money, that's fine. Yeah, you just have to make sure you show taxes. Can I have real ID with asylum and work authorization? You may be able to, yes. With a work permit and your social security, you can go to the DMV and they'll give you the real ID. Um, All right. So I am going to go on to YouTube now and answer some questions there and then Instagram. So go ahead, put your questions in the comments as I just scroll through and catch up on your questions. Can I get a T visa because my boss gave me a wrong document and say it's my extension? That could be fraud. Let's talk more. I want to hear more because if they gave you the wrong document on purpose and told you, oh yeah, we applied for your extension, here it is, and you walked away saying, okay, I can continue working, and because my boss has given me legal status here, then that's fraud. And if they gave you a fake document, fooled you into thinking it's the real deal, it's an immigration document, and that caused you to keep working, that's labor trafficking by fraud. So, we need to talk more just to get specific facts, but yeah, that sounds very fishy. Please, attorney, do you have office in Baltimore? Can I have your contact? We are based in Florida. But we represent clients in all 50 states and the globe, so we can help you. Go to the description of this video and you'll see our phone number. We are 24/7. So no matter what time you are thinking about your immigration, you can call. You're welcome to call, and we can go ahead and get you on the schedule. Our schedules are filling up very quickly, so make sure that you take action so that you can get it on the schedule. Once you start to apply for a T visa, will you receive any document that shows that you're in process before you get a work permit? So you would get your receipt notice as well as maybe a bona fide determination letter. Receipt notices are taking about 4 months because they're backed up right now. So I'd say 2 weeks to 4 months. And then bona fide determination letter comes about 2 months after the receipt notice. Is traveling to Puerto Rico considered domestic travel? And am I subjected to scrutiny? I'm a permanent resident. it is considered domestic travel. As long as your permanent residency is valid, current, and you don't have any criminal record in your background, then you're at low risk. But keep in mind that I'm not your attorney. I don't know your case, and so it's always important to check with your attorney or an attorney before making any plans. I also have a 10-year visa. Can the H-2B visa end? So I guess if the H-2B visa ends, can you continue on your 10-year visa? So you would have to enter the country with that 10-year visa for you to be here on that visa. So if you do have a visitor's visa, you'd have to re-enter with that visa for it for your status to show that you're now here on a non-immigrant status. But keep in mind that you're not able to work on your tourist visa. What's the timeline for EAD based on pending I-485? About so 6 to 12 months for the VAWA. I have a 10-year green card. Can I marry to my spouse and start filing? Or will he get his EAD and SSN? If it's possible, but the conditions have to be absolutely right. Now, if you're the spouse of a green card holder, you have not overstayed. You your I-130 is pending and now you have a current priority date, that is when you can qualify for adjustmental status. So I know that's a lot to take in, and maybe half of the stuff I just said, you can't even make sense of it. That is, guys, is where that's our job, right? That's our job for you not to think about it, for us to worry about it, and for us to tell you it's time to apply or what to do. So, in cases where your spouse is a green card holder, you're here in the US and you're trying to figure out, can I apply for the green card? While I'm here in the US, it's time to give us a call and we can evaluate your facts and determine whether it's right for you and whether you can qualify for adjustmental status. Can you expedite T visa application? It's possible if there's any kind of emergency or humanitarian decisions. Are they still processing work permits after bona fide letter for T, and how long? Yes, they are. We've gotten a couple of the bona fide work permits. I have received bona fide determination notice and EAD. Will it protect me from deportation? It puts you in a much better position for protection. Now, keep in mind, if anything changes, in your background, that can easily, it could be revoked. But the best thing you can have is a work permit, which is considered an EAD, and a bona fide determination. Bona fide determination notice puts a stay on removal proceedings, and your EAD shows that you can legally work here and that you can temporarily be here until a decision is made in your process. How much time is it taking for a T visa approval? I'd say over 18 months. I have filed expedited request for a T visa with VSC, and how long will it take to get a response? It could take about 30 days. So usually they take about 30 days to respond. Hi there, Karen. What if you're waiting for a decision for the approval? If you're waiting for a decision for the approval, keep in mind, if you file a petition and you don't have a pending adjustment of status, that alone does not give you protection from removal. So you just have to be very careful. All right, so now I am going to Instagram, and then I'm gonna call it a night so I can continue working in the morning. All right. Does a travel document automatically come with a T visa? No. Keep in mind that the focus of the T visa is not the travel document. The T visa is for people who have been in a very tough situation here in the US. And usually the last thing that they're thinking about is the T visa, their number one priority. And not, I mean, the last thing they're thinking about is the travel document. Their number one priority is to get safety, protection, security while being here in the US. And so that is the main goal of the T visa. Now, if you do need to travel, which I would say that's very tricky right now, very risky right now to do that, especially on a T visa. But if you absolutely have to travel, you can apply for a travel document right now. That may change in the future, but right now you can apply for a travel document. But keep in mind, having a travel document is not like having a green card. That travel document um, the officers do have a lot of discretion. And if it's not arbitrary, meaning they can't just jump up and say, I don't like you. Uh, I'm not going to let you into the country, right? But if you have a travel document and they find something in your background that is, inconsistent, or there's an offense in your background, they can then turn around and deny you entry. So you have to be very careful. I got married in 2022. We filed for a marriage visa in 2023 of May. We did the interview last August, and he has a temporary 2-year green card, and he's supposed to file the I-751. What are the next steps normally? So within 90 days before the card expires, if you're file, you have to file jointly unless, of course, there's a divorce or mistreatment. They can file using a waiver. But within 90 days of expiration of the green card, then apply for removal of conditions. And in the case where you do still have your marriage intact, the both of you have to sign that form. Then you get the receipt notice and an automatic extension of about 48 months, which enables him to continue to be a green card holder while the process is pending. He can use that to travel and to work and do everything he does as a green card holder. And then what they make a decision within that time. Aggravated felon, been out of the country 17 years, never spoke nor saw immigration officer. Can my American citizen daughter file for me? It may be possible after a specific amount of years. So it might be possible, but it also depends on a lot of factors, like what are the facts, what is in your background. In this case, you still have to apply for at least permission to reapply to enter the country, since aggravated felon is a permanent bar. Is marriage the only way to adjust your status? No, absolutely not. But if there are any other ways, it's going to depend on your specific facts. And this is where the scheduling an appointment with us is going to be very important. Mhm. My prima facie sheet determination letter expires 6 months. I have to worry. They usually automatically issue a new one. My asylum was approved last year, December. Am I protected till I apply for the green card? That's the best case scenario. You have protection, yes, until and even beyond when you're applying for the green card. Oh, thank you for the compliment. I appreciate that. How T visa work? So I say this: the T visa allows you to get 4 years work permit, 4 years uh, 4 years work permit, 4 years protection. After 3 years, you can apply for your green card. Your children under 21 can get it with you, as well as your spouse. If you yourself are under 21, your parent and sibling and spouse and children can get it. Now, how do you qualify for this? If were in a situation here where you were um, held again, you were subjected to a situation against your will, then that you need to give us a call so we can talk about it. If you're, for example, your employer had you working but stopped paying you or paid you late, mistreated you, subjected you to really harsh work conditions, held the immigration status or lack of immigration status over your head, that can possibly qualify you for the T visa. But that's where we ask questions. And our questions are going to be super important to determine what options are available for you. Oh, thank you so much, Cromwell. I appreciate that. I got married last December on active F1 and filed my AOS in May. I got an interview letter scheduled for August. Is this looking good? Anytime I say this, you have an interview, that's an opportunity. You're not going to get to the green card without the interview. So it's going to be your time to go in there and get that green card. You just have to make sure you prepare for that interview. Can a person who was previously married and got their green card through marriage 4 years ago and is now divorced remarry and petition for their new spouse, or do they have to wait the 5 years? 5 years. They have to wait the 5 years. Um, yeah, if they apply within the 5 years of getting the green card, automatic denial. Really, it just comes down to that, and opening a can of worms. They would reopen the past cases as well as the current case, looking for fraud, and they would presume too that it was not a bona fide marriage, the current one. So you have to be very careful. So, is it safe to fly domestically with resident card and real ID if you have charges on background from 23 years ago? It depends on what the charges were, and were they aware of the charges when they gave you the green card? So whenever it comes to criminal offenses, it's very important. Here at the firm, we do an evaluation of the record to determine what consequences it's going to have in order to advise how to move forward. That's very important now, especially if you're going for citizenship or your green card. Good evening. How long after I take my picture for my TA and EA will I wait for the cards? I did biometrics on June. So it depends. It could be a couple of months. So um, it depends on the case type as well. Good evening. How long after I do biometrics will I wait for? And I think it's the same thing, same question. It could be, it depends. It depends on the application type. I don't know what type of application you have. All right, guys, thanks so much for your time. I appreciate it. I am going to be back tomorrow where you can ask. So if I didn't get to your questions, please make sure that you save those questions and come back on. Like, subscribe, share, hit the notification bell, because that's how other people are going to start seeing this platform and the information that can empower them through their immigration journey. And that's how you can also see me when I come on live. And if you're available, you can come on live as well and ask your questions again. So thanks again for your time, and best of luck, guys. I say this every day. You look at the headlines, there are horrific things going on. But what we have been doing here is we have been approaching our cases with being solution oriented. We are solution oriented. There is a solution to every problem, and that's what we're focused on. So do the same. Take action. Don't hide under a rock. Do not act as if it's not happening. Be strategic. And we're here to help. We're here to help. So make sure you get on our calendar so we can talk to you, we can ask the questions, and we can tell you what options you qualify for and get started right away. Because yes, the stakes are higher, but it is still possible, guys. So stay positive, be faithful, have that faith, and be solution oriented. And most importantly, take action. Don't stay inactive. Take action to figure out what solutions are best for you. Have a great night. I will see you tomorrow. Bye bye.